I think we should start. People are continuing to join us, but I think they'll keep on joining in for next few minutes. So, hello, namaste, and good evening, everyone. My name is Nima. I'm a member of Kalpavriksh, and on behalf of Kalpavriksh and the National Working Group on Community Conserved Areas, we would like to welcome you today for this very important conversation. We all know that in last few months, there have been a series of legal changes, particularly related to environment. And one that we are talking about today is the latest, which is the Forest Conservation Act. The rules to the act were amended in 2022, and the act has been amended this year. A number of concerns have been raised by many of us who are here in the conversation today and many others in last few months about these changes. And we've also seen that many of these concerns have not been taken into account through the official channels by which they should have been taken into account, including the Joint Parliamentary Committee that was set up for looking into the submissions that came from citizens. Very soon, the act will be enacted as soon as it is signed by the President of India. So today we have with us a renowned Supreme Court lawyer, Ritwick Dutta, who's been engaging with the law for many years, for decades, and has actually worked very extensively with the Forest Conservation Act in many of his cases. So who could have been better than him to call for a conversation today? We also thought that since the law is here now, one of the focus, other than trying to understand the various provisions of the law and what has changed, what does it mean for much of our work, also look at how do we engage with the law in future, both for our lands, our resources, the conservation efforts of the communities, the livelihood efforts of the communities, laws like Forest Rights Act. What does it really mean, and how do we engage with the law in future? So with that very brief introduction, I would like to welcome Ritwick, and I would also like to invite my colleague Neeraj Vagholikar, who has also worked very closely with Ritwick over the years, to please give us a short introduction to Ritwick, and then we can move on with the presentation. Thank you very much.
Thanks, Nima. I'll briefly introduce Ritwick because I think most of us know him, and I don't want to hold him back from educating us. So for the last 2 decades, Ritwick has been the leading environmental lawyer in the country. He's also been a personal friend and colleague for over 2 decades. And he's most well known in the last decade or so, particularly because of taking up issues on behalf of both biodiversity, the environment, and affected people in the NGT, the National Green Tribunal. But he was also involved with this in its earlier avatar, what was the National Environmental Appellate Authority. And in both these institutions, he was also involved through his clients in actually activating those institutions, which are mere laws, and they were not functional in that sense. Since we are talking about the Forest Conservation Act 1980 today, over the last 2 decades, he is very closely engaged with this law. Particularly the Godavarman case in the Supreme Court, appearing before the Central Empowered Committee. And he is the co-author of the book Supreme Court on Forest Conservation. And even after
Hello?
Yeah. Neeraj seems to have vanished.
I don't know whether it's Neeraj's screen. Neeraj is frozen, right?
Yes, Neeraj, I think he's dropped off.
It's fine.
Yeah.
So should we go ahead or should we
Yeah,
wait for
I
Neeraj?
think
Yeah, Neeraj is here. Neeraj is here.
Neeraj is here.
Hi, Neeraj. We lost you for some time. Could you just repeat a couple of lines before you dropped off? You're on mute.
Yeah, I'm so sorry. Somebody was not happy with the praise being sharply been involved in understanding aspects of its act in relationship to the FRA, both from a policy perspective as well as through litigation. So now I'll pass it on to Ritwick and not let him take over.
Thank you, Neeraj. Thank you, Nima. It's always a great opportunity to interact and share. And always, whether it was Biodiversity Act and other laws, including Wildlife Protection Act. So, am I audible?
Yeah, you're audible. Thanks, Ritwik. I have a request to all others who are joining. Please mute yourself unless you're asking a question. A request to all the participants to please mute yourselves. Thank you.
Is my screen also visible? My PowerPoint presentation?
Yes.
Yes, Ritwik. Yeah.
Fine. So thank you. Let me start straight away.
Okay.
Right. So
I'll just request who is using Redmi Note 7 Pro to please mute.
I think admin can mute everyone. So if admin can just, because explaining it to everyone is very difficult.
Okay.
Yeah, we just did that. Thank you.
Sure. So, Neeraj and Nima, thank you. And let me start based on the discussion that what I said, that, my presentation here will not be to critique in the form in which critiques were done prior to it becoming a law. Now that it has become a law, right, we will have to see it not from the perspective of each and every point, but how can we interpret the law that exists today. So first and foremost, it's the first law where the name is actually now a Hindi name, Van Sanrakshan Eva Samvardhan Adhiniyam, right? That is the new law, name of the law. It has retrospective effect in the sense that the 1980 law will now be known as the Van Sanrakshan Eva Samvardhan Adhiniyam. Now, I think Forest Conservation Act is really a very interesting law. Why it's interesting is that it is among the shortest law, definitely in the field of environment. It's just a 1.5-page law. So if you look at it in terms of interpretation, it's not really a law like any other, whether it's the Indian Forest Act or Wildlife Protection Act or Environment Protection Act, which goes into various sections and all. It's a fairly limited law. And so it's important to understand how even a law which is just 2 pages or 1.5 page has led to the longest engagement of the Supreme Court on any issue. That's something which is important. And that actually led and prompted the government to actually come out with this amendment itself. Now, if you look at it here, sorry. Now, if you look at here, this is the Amendment Act. It received the assent of the President. And let us look at go further and look at what are the statement of objects and reason for this law. Now, the main reason that the government has come out with is saying that prior to the judgment of the Supreme Court dated 12/12/1996, the provision of this act was applied only to notified forest land and not to revenue forest area non-forest use was allowed through permission granted. Subsequent to the judgment, the provision of this act was applied in all recorded forest areas, including those which have been put to non-forest use. So in real sense, the main crux of this amendment actually is on what is a forest. And in what is a forest, the statement of objects and reasons states that it's actually in 1996 that the Supreme Court created this problem by expanding the scope of the law. Because 1980, when Forest Conservation Act came in, it was a very limited law. It was applied only to government forest, notified forest, and declared forest. Suddenly, the Supreme Court got up in 1996 and said, sorry, we want to apply this law to all areas which are forest, even in the dictionary sense. Now, what they said very clearly, the government's objection is that, well, Parliament decided to limit it to notified forest. Supreme Court decides to expand it to dictionary meaning forest. What we are doing today is to go back to what was the original intention of the 1980 law, that is limited to only notified forest. And therefore, what we are doing is only a correction arising out of what they call as judicial activism, or someone should say judicial adventurism. So it was a judicial adventure that they got into and expanded the scope. And what we are doing is bringing them back to what the original intention of Parliament was. And they further said, well, there was misinterpretation of the act. All of these things happened. Now it's important. And in many of the critiques that I've seen, many of them all, have been quite good. Let me be very honest, insightful, and every critique that has gone in has actually people have put in a lot of effort. Just one point that I personally differ is the fact that Godavarman did not enlarge the scope of this act. The 1980 Act, which was originally an ordinance, became a law passed by Parliament subsequently, itself provided for a wider definition of forest. So let's look into what it means. Now, if you look at the 1980 Act, what does it say? Notwithstanding anything contained in any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, any order directing that any reserve forest shall cease to be reserved, any forest land or portion thereof may be used for non-forest purpose, and any forest land or portion thereof may be assigned by way of lease or otherwise to any private person. So this is broadly. So if you look at this diagram, what it is, the basic premise of it is no dereservation of a reserve forest is permitted unless you take a prior approval of the central government. No non-forest use is permissible unless you take prior approval of the central government. And secondly, no clearing of trees is permissible unless you take permission of the central government, and similarly lease. Now let's be clear about it, certain points. Number one, after the 42nd Amendment of the Indian Constitution, forest moved from the state list to the concurrent list. Once it went to the concurrent list, the central government took over only one power with it, only one aspect, and this is mentioned in the Sarkaria Commission report on center-state relation. That one power is that the state are entitled, is the authority to divert forest land for non-forest purpose. The state is the authority to de-reserve a forest land. But before you exercise that power, come to the central government for prior approval. That's it. So the authority to use forest land for non-forest purpose from the first stage to the last stage is still the state government. And I will show through the Indian Forest Act and other Forest Act that the ultimate decision as to whether a forest land should be used for a non-forest purpose is the state government. Second, very important part is the Forest Conservation Act was not concerned about trees. If a state today decides to cut every single tree, even assuming that this amendment did not take place, the central government has no role. If Andhra Pradesh decides, if Telangana decides, if Manipur decides to cut down every single tree in its state, central government has no role under the Forest Conservation Act. Central government comes in only if there is breaking up of land. So the moment there is breaking of land for non-forest use, then the central government's approval is required. Clearing of trees is also not prohibited under Forest Conservation Act. But if you clear trees for planting another kind of tree, then Forest Conservation Act comes. So therefore, the right of a state to decide on what it wants to do with a forest remains unaffected by virtue of the 1980 Forest Act and even as a result of the 23 amendment that takes place. What it does basically is it absolves the central government of its constitutional duty to protect forest, wildlife, and environment. Under the directive principles of the state policy, it is a duty of the central government also to protect forest. What the central government today is saying is, well, we are actually leaving it to the states. It's important to look at it. Now I come to the next very important part, which is flowing from the first part of my emphasis which I had given, is that the Godavarman case enlarged the scope of the Forest Conservation Act and included areas which are dictionary deemed and others, which was not the original intention of the 1980 Act. Now, my point is that the trigger for this amendment that took place in 23 is not the Godavarman case. The trigger for it is actually the Supreme Court judgment in the Aravali matter called Narinder Singh versus Divesh Bhutani. Now, this is important to read for the reason that in Narinder Singh versus Divesh Bhutani, the Supreme Court Justice Oak, a 3-judges bench of the Supreme Court, considered the interpretation of the Punjab Land Preservation Act. But while doing the interpretation of the PLPA, they obviously had to interpret the Forest Conservation Act. What it says, something very important, is clause 2, 3, and 4 of the Forest Conservation Act applies to any forest land which may necessarily not be a reserve forest. If you see now section 2, it says first part is reserve forest. The second part of it says any forest land. So therefore, it applies to every forest land in respect of which no declaration has been made either in 27 Forest Act or any other law relating to forest in force in a state. Therefore, it is not a case where the 1996 judgment goes beyond what is prescribed in the 1980 Act. And I'll just go back to show you what the 80 Act again is. if you look here, this is what section 2 says. If you look here, the first part, clause 1, it says any reserve forest. Number 2 uses the words any forest land. The word reserve forest is not there. The word government forest is not there. The word notified forest is not there. It uses the word saying any forest land. So the moment 1980 law emphasized on the use of the word any forest land, it is irrespective whether it is notified, recognized, or classified by the government or any record. So therefore, this entire statement of object and reason and the basis on which they've come out with is faulty, because it undermines one of its objectives. That it is today stating that one of the reasons for coming out with this law is to increase forest cover. But what it is doing is just the opposite. It is restricting the protective regime of the Forest Conservation Act and the central government's oversight only to areas which are declared and notified as forest in government records. And this again, I again emphasize, is not what was intended in the 80 Act. Therefore, what has been today curtailed is the scope of the 80 Act and not the scope of the 96 judgment. And if you look at the 96 judgment itself, the Supreme Court said, we are only clarifying what is the settled position of law, that the Forest Conservation Act applies to all categories of forest. So therefore, what it is here is that, again, when I'm looking at here, if you see, this is the Narendra Singh judgment. Legislature has used the word any forest. The intention is to bring all the forests, whether within the sweep of the 1980 Forest Act. And this is where I think we must understand or appreciate that why did this Amendment Act come in now, not after 96, is because of this fact that Narendra Singh's judgment clarifies in a manner which 12-12-96 does not do. Besides, the 12-12-96 judgment was a 2-judges bench, and this is a 3-judges bench. So therefore, this has a far greater binding or a value and something which becomes the law. So it says dictionary meaning is also there, but in addition to that, it has to take into consideration the fact that it applies to any forest land. Now let's come to the next part of it. Who is the authority to decide on the forest land itself? Now, if you look very clearly here, the authority here is whether it is the central government or the state government. Now, the NGT, in a very significant decision in 2012, Vimal Bhai versus Union of India, I also thought it's an opportunity to just look at him because last year he died. He played a very, very important role in environmental litigation. We had the opportunity to represent him in many matters. And one of them was this particular matter which concerns a hydropower project in Uttarakhand. The issue came in is whether an order passed by the central government under Forest Conservation Act is appealable before NGT or an order passed by the state government. And what the NGT stated is very, very important and is the law today based on the Forest Conservation Act itself. It mandates, and these are the words from the judgment, that no state government shall accord permission for use of forest land for non-forest purpose without obtaining prior permission of the central government. What it means here, again, I emphasize here is that the word in this law is that the power is with the state government to decide as to whether it wants to divert forest land or not to divert forest land. If it decides to divert forest land, it needs to take prior approval of the central government. But if it does not want to divert forest land, There is nothing in the Forest Conservation Act which states that diversion has to take place, or the states can necessarily have to abide by an order to divert a forest land. The scheme of it is such that the ultimate authority, even after the Forest Conservation Act, Amendment Act of 23 or the Act of 1980, the proposal for diversion must emanate from the state itself. And this is what it says is, from the judgment, Section 2 of the FC Act mandates that as and when the state government decides to permit the use of forest land for non-forest purpose, it has to pass an order to that effect. That's it. And without an order of the state government, no forest land can be diverted for non-forest purpose. That's it. So if you look again here, this is what it principally means. Now if we now focus a little bit on what the the Indian Forest Act says. Now, why it's important to focus on the Indian Forest Act is that which is the authority to divert the forest land. Section 26 says acts prohibited in such forest. Now, this is where the issue comes in, that with respect to reserve forest, it says any person who clears or breaks up any land for cultivation or any other purpose. These are acts which are prohibited. And any person means anybody, even a government agency. In such a situation, if any person wants to clear or breaks up any land for cultivation or any other purpose, then it can be done only in permission of writing of the forest officer concerned. Therefore, even after the Forest Conservation of 80, unless and until a DFO gives the permission, no forest land can be diverted and no forest land or tree can be cut in that area, even after the central government has granted an approval. And even if the central government gives a prior approval, the state government can still say, well, we had a change in mind and we are now not going to divert it. So state government can come in initially by not processing the proposal. State government can come in later by saying, well, you have given us conditions which are difficult for us to implement. You want us to put in such mitigation measure, declare 3 times the area as compensatory afforestation, fence the area, put chain link fences, declare it as national park. Well, we can't do it. So therefore, the state can very well say, well, we don't want to divert the forest land. So therefore, we are not going to issue the order under Section 2. They can very well do that. And for the matter, we are not going to issue orders under the Indian Forest Act, because Indian Forest Act of 1927 is completely within the domain of the state government. The central government has no role when it comes to the Indian Forest Act of 27, as well as the other laws that are there. Now, if we look at if you look here, what are the highlights of the 1980 Act, which I stated is, firstly, it applies to any forest land, 80 law. The FCA did not define forest or forest land. It did not define it. The amendment bill now goes into the domain of stating what is forest and what is not forest for the purpose of FCA. The power to de-reserve and non-forest use remains with the state government. The Act did not prohibit but only restricted the de-reservation and non-forest use, and only prior approval required. That's it. Now, what the amendment does is that now for the first time, it specifies the land to which FCA applies. So from the 1980 position, which was that it applies to any forest land, it now gets restricted to lands declared or notified as forest under IFA, etc. Now, this is very important. Large portions of our forest is actually not declared. There is only an intended notification. There is only a draft. It is only at the proposed stage. They call proposed reserve forest. The word is declared or notified. So you restrict it. The next part is interesting. It says land recorded as forest in government records, local body, community, council, or other authority, including now they've said forest department. Absurd as it may seem, in Devesh Bhutani case, which I referred to earlier, the government of Haryana has stated, and the Ministry of Environment was silent on it, stated that forest department record is not a government record. Because forest department is not a government department. It is an autonomous department. So now they've said forest department record is also a government record. So here it says land recorded as forest in government record, local body, community or council or other authority on or after 25th October 1980. Now, there's been a lot of debate on this issue. It means that even if the area was notified or recorded in any of it before 1980, also it will be treated. But very important is this fact, which we must keep in mind, is that even if a community has kept a record, if it is in a PBR form, it's a village panchayat record, those areas will also be treated as forest, even under the Forest Conservation Amendment Act 2023. So therefore, there is apprehension, and rightly so, but if you look very carefully, the word government record is wide enough, where they've used the word also saying community record is also to be treated as government record. Now, then it comes in stating that where will FCA not apply? Now, there are categories which are exemptions. Now, for the first time, they brought in saying FCA will not apply to 1000 square meter areas diverted along rail line and public road. Such tree plantation, reforestation, which are not in notified, declared or government record forest. Now, this is very, very problematic. On the one hand, you want 33% of the country to be under forest and tree cover. On the other hand, you are saying that even if we carry on reforestation, that area will not be treated as forest for the purpose of Forest Conservation Act. So therefore, there is no protection under the FC Act for any, and to me, this is of great concern, because if there is a community conserved area which is not in a declared or notified or recognized forest, those areas will not get the protection under Forest Conservation Act. If there is an effort that has been put in by people to raise natural forest, to regenerate an area, so the question that comes in is, what is the use of using the word samvardhan when anything that is an outcome of regeneration enjoys no legal protection under this law? So therefore, if you look at this, only tree plantation and reforestation that is carried on in notified forest land, declared forest land, or recognized forest land is the one that will be protected under the Forest Conservation Act and not others. This is a very, very regressive part. And then they said, again, 3 more categories. Strategic linear project of national importance and national security. Now here, I just want to give my view on it. There has been some writing, and with due respect, everyone can have their own interpretation. There's been some writing where they said, well, because of 100 kilometers along international border line of control and line of actual control, the whole of the Western Ghats, Eastern Ghats can now be used for linear projects without FC Act clearance. My interpretation is that that is not a correct interpretation, for the reason that when we look at the coast and the sea, there is no international border, we refer to territorial waters. And the context and the basis and the objective of the law also has to be seen. Because if it was ports, if it was harbors, one can understand. But why would someone want to divert and create a linear project once your coast is already full of linear projects on the coast itself? So therefore, by strategic linear projects of national importance and national security is limited only to international land borders, line of control and line of actual control, and not to those which are on the sea or the ocean, whichever that is there. That would be territorial waters. So therefore, the provisions of FC Act will apply to coastal states and will not be affected because of this particular provision. Now, the next part is up to 10 hectares for construction of security related infrastructure. Now, this is very problematic because it effectively means that what is security related infrastructure? It can be a stadium, it can be a guest house, and 10 hectares is a huge area, and it doesn't say what is the cumulative impact. So you can have one agency taking up 10 hectares, the next one is adjoining another 10 hectares. What happens about corridors? What happened about, again, community conserved areas? What happens about ecologically sensitive areas? What happens about areas where people depend on the livelihood? So straight away an agency today says, well, we want it 10 hectares and there will be no central government oversight, again, I'm saying, because this proposal will still have to be processed to the state government. So just to clarify, again, for security related infrastructure does not mean that any agency can today go and say, I want to cut down all the trees. No, they will still have to process it through the forest department. The forest department and the state government is within its right to say no. The only thing is, it will not go to the central government for a prior approval. If they get an approval at the state level, that itself is good enough. And next here is defense related project, camp or public utility project of up to 5 hectares. Now again, there was some interpretation given saying, oh, a hydropower project is also public utility. What if they apply the one? See here, let's make a distinction between 3. The first part of strategic linear project is only limited to 100 kilometers along international land borders, line of control and line of actual control. Number 1. Up to 10 hectares for construction of security related infrastructure can be anywhere. Anywhere. That's it. It can be anywhere in the country. And then defense related project, camp or public utility project of up to 5 hectares is in left-wing extremism affected areas. That's the point that is there. Now here, obviously you cannot make any significant dam with 5 hectares of land. So again, the basic principle of interpretation is purposive interpretation and the mischief rule. What is the mischief that it tried to address? Yes, these are small projects, they needed it. But the question that is there is, what is the word related? Today, the defense can say, well, we need a cinema hall also because it entertains the troops. It's a defense-related infrastructure. So you can have non-site specific projects that are there simply because the forest land is available for free. And that is where the problem comes. Because all that it requires is their willingness to plant some equal number of trees. That's it. So therefore, we are actually opening up large areas without any control by the central government. It's a clear case of the central government absolving itself of its constitutional duty to protect forests and leaving it to state. Because see, we will have to understand that FCI Act has to be looked from the federal perspective. In 1980, the central government felt that the state cannot be fully trusted when it comes to forest matters because they are subjected to local pulls and pressure. And therefore, a holistic view needs to be taken by the center. Today, we are saying all decision needs to go to the state, which in a way may look fine. But the fact is the problems that existed in 1980 have not gone away. If there were pulls and pressure in 1980, it is very much more active now after 40 years than it was at that period of time. So we must keep that also in mind, that the states have been given much more power as a result of this amendment. And the center is actually absolving itself of its duty and the responsibility that it has. Then it says FCA will not apply to establishment of zoos and safari. Now, this is my personal view. It is not an interpretation. I would still say that in the list of problematic areas with regard to the Forest Conservation Act, it's my personal view that zoos and safaris are still a lesser evil. What we need to be concerned about is more about other kind of activities that are happening, because it is zoos and safaris that are established, which are run by the government, which are to be in forest land. But what is problematic is the next part. That establishment of zoos and safari is excluding protected area, but ecotourism facility are within protected area now. So therefore, you see, they've made it very clear that, okay, fine, zoos and safaris will be outside. And let's accept it that there are a lot of forest areas which are only forest in paper, which are reserve forest only in paper, which sometimes can be used. But I'm not getting into too much details about it. My concern is, what is ecotourism facility has not been defined. What is the facility? Now, and second, it says, if it is part of a working plan or a management plan, then it is permissible in a national park, in a tiger reserve, and in wildlife sanctuaries. It's a permissible one. Then they say survey, reconnaissance, prospecting, again, is to be treated as not requiring it. Now, again, there's a fundamental issue that comes in, is that, yes, it may be true that the impact because of the survey or prospecting is very limited. You may need just 1 square meter of land to make a hole. But the question that comes in is that, are we going to allow every single forest area, biodiversity rich area to be surveyed? If I do not intend to rent out my home, why should I allow a passerby to come and look at my home? Now they're saying, well, we want to look at every place whether it is worth exploring or whether it is worth exploiting. And therefore, any agency can today coming in and say, well, it may be a national park, but I want to see whether there is ABCD minerals or prospects that are there, or whether there's a hydroelectric potential. So we open it up again without any due diligence. Next, I just have another 2 more slides. Now, when we come to the Forest Rights Act, I'll take more when it comes to the question answer. There is a lot of issues that come in, but it's important again. For one aspect that I want to highlight here is that if you look at the statement of objects and reason of the Forest Conservation Act Amendment 2023, what is stated is that, well, it is Godavarman case that extended the scope to include deemed forest, dictionary meaning forest. And it is the Supreme Court that has actually created all of it. All the problem, all the misinterpretation or interpretational problems, and led to a huge problem in the country in terms of application of the law. And if you look at the Forest Rights Act, what is the definition of a forest land? Forest land means land of any description falling within any forest area. Now, the word again is very important. The word used here is within any forest area and includes unclassified forest, undemarcated forest, existing or deemed forest, protected forest, reserve forest, sanctuaries, and national park. So, deemed forest is a word that has got approval and is part of the statutory law of a law enacted by Parliament. Now, this particular amendment to the FC Act restricts the scope of forest land by deleting deemed forest and stating that you must be a notified forest, declared forest. So therefore, one law goes into and hits the provision of another. But then there is one very important aspect that is there, is that there is no overriding provision in the Forest Conservation Act, Amendment Act of 23. It does not say, notwithstanding anything contained in any other law for the time being in force. Because it does not have any overriding effect of the FCA, this amendment, the definition under the FRA, so far as forest land is concerned, will continue to be there. And what is deemed forest is not a judicial creation. It is not a judicial innovation. It is today part of the law of the land, of a law enacted by Parliament. So therefore, for them to say we will not consider it as forest land is only to the limited extent of the central government's power when it comes to use prior permission to be taken from them. It does not affect the powers under Section 5, for example, of a forest rights holder or of the Gram Sabha or a village level institution under the Forest Rights Act, because it is very clear that the holder of a forest right under this act, whether it is a Gram Sabha, shall protect wildlife, forest and biodiversity, ensure that the habitat of the forest dwelling, scheduled tribe and other traditional forest dweller is preserved from any form of destructive practices affecting the cultural and natural heritage. Therefore, my interpretation is that the FCA amendment, because it does not have an overriding provision, does not in any way affect the rights that are there under Section 5 or overall so far as the forest rights is concerned. There are problems because, which I will deal with maybe in the conversation, is that the central government's oversight of the FRA is gone, which the ministry was exercising when it comes to these categories of projects. But let's be very clear, a linear project is not excluded. It is only a strategic linear project of national importance located within 100 kilometers of the international border or LOC that is expected. A hydropower project, a mining project within 5 kilometers, 1 kilometer of LOC, and all others will still require to go through the rigors of the Forest Conservation Act. And therefore, if you look here, my last slide is that the following section, if you look at it here, is we have a new section now, and that is why the following land shall be covered under the provision of this act. This is 1A. We have a new section now, 1A, which says the following land shall be covered under the provision of this act. Land that are declared or notified as forest in accordance with Indian Forest Act, land which is not covered under Clause A, but is recorded as government in records, which is again is there, the following categories of land shall not be covered under the provision of this act. But very important, they do not have an overriding provision. It does not say notwithstanding anything contained in any other law for the time being in force. So therefore, this is only a limited one for the purpose of these kind of diversion, which is also deeply problematic. But my point would be that this does not give a clear green signal for the government to override the provisions of the Forest Conservation Act, Forest Rights Act. And most importantly, what I would like to end by highlighting is that even after the amendment of 2023, the ultimate power with regard to diversion or the decision to divert a forest land or not still remains with the state government. It does not vest with the central government. So if there is anyone who has lost power in this whole game, it is the central government. And anyone that has gained power here is the state government, so far as the power to divert forest land. And therefore, the provisions of the FCR of Forest Conservation Act, read with the Forest Rights Act, one can creatively interpret, though there are still a lot of areas where there are issues which can be challenged and which I'm definitely sure many groups will be actually taking it to the court. So I'll like to end here. I hope I've covered all. I did not want to go into the objectives of it in great detail because a lot of them were already covered in many other discussions which were held on this topic. So I limited myself only to the limited role of the state, the role of the state government, as well as what communities powers are there, community powers are there so far as FR is concerned. Thank you.
Thank you so much, Ritwick. Amazing. That was really superb presentation. And I'm sure there are lots of questions still in the minds of people. And I can see some already, and I'm sure some they will be adding. Thank you also for reminding us about Vimal Bhai and his immense contribution. We would like to pay our respect since we are all here today. I just, before we open up for the participants, I just wanted to clarify a couple of points, and taking from the last statement that you made about the state-central relationship and how this act actually empowers the state governments and not really reduces their power. So what I understand you're saying that whatever exemptions there are or whatever definitions that this act is providing us, it's only as far as central government's power for prior permission for diversion of forest that on a proposal that has already come from the state government. So it's only, actually legally speaking, that's the only sort of power that this law and the definition within the law of the forest would have. The question in my mind was then, suppose there is within this 100 kilometers, it's a project of strategic importance, and the state government and local people. My second question is about local people, but first the state government decided that they did not want to go for a strategically important project. Would they be able to actually say no to the central government to if it is of security concern? Would that, if the proposal is of importance to the central government, how much power would the state government have in projects of these kinds, strategic importance? The second question then to me is that you also mentioned that primarily the proposal is coming from the state government, and now in this law, there was earlier in 2022 rules a provision for consent of the Gram Sabhas to be able to say no to a project was included, which has been removed from the rules. Now, we would then believe that it's only been removed from the prior permission process. So in the state government's process of diversion of forest, there should be a role, and there must be a role, legally speaking, of the communities to consent or not to consent to a project that is coming. where in that project, from our next strategy point of view, where in that process of the state government is it a legally binding requirement for the state government to respect FRA and seek the permission of the local communities? Just quickly, these two questions. I have many more, but we'll open it out to other participants.
Right. Thank you. So in respect of the second question, you see, there is bound to be a problem there. And you're absolutely right. Because presently there is no format for that. Because what happens is whenever there's a diversion, the diversion proposal format has been prepared by the central government, right, under the FC rules. Now that assumes that all the proposals will come to the central government itself. Right, so it presumes that all, because since the state has no power to divert forest land, this format has been prepared by the state government, central government, and has to be followed for all diversion. Whether it is less than 40 hectares, then it goes to regional office. More than 40 hectares, it comes to the central government in Delhi. That's how it has happened. Now my point would be that as of now, despite the fact that the proposal will still require a clearance from the state government, presently, there is no format for that, right? And therefore, this is one area which will require some work so that all instances of diversion of forest land which do not need to go to the center, then in such instances, the similar process that is normally required for such a project, which goes to the center, should be actually done at the state level itself. Because if you look at it here, all the processes other than FSC or REC process is to be taken at the state level only. So it is the collector's certificate, it is the Gram Sabha resolution, all of this anyway has to be done at the state level itself. So what will be required now is actually to convince, or basically say, later one can always go to court, is to say, well, in light of the fact that in these kind of projects, since it will not go to the central government and the final approval authority will be the state, therefore, since your existing process is only looking at the IFA procedure, right, you need to include the provisions with regard to the Forest Rights Act also within the IFA process, so that all of it becomes part and parcel of it. Now, if you look at state amendments, I've looked at it, say, in case of Maharashtra and other states, the provisions of Forest Rights Act are part of the Indian Forest Act, right, by state amendments. So here it will be through a process of amendment, either in the rules or through notification issued, saying that in respect of projects which will not go to the center, the process of Gram Sabha and all will still have to be done and process at the state government level.
So I would say for all projects, because at the central government level now, there is no requirement for the Gram Sabha consent. So irrespective of whether the projects are going to central government or not, state governments need to include this.
Yes.
Thank you. I think we can open it up for questions from other regions now. There were some specific questions related to particularly forest in different states, particularly of the northeastern states. So maybe I can ask, if Sahil is there in the participants, then please unmute yourself and you can start with the questions related to Arunachal, and then maybe others can add. और हम ये भी बोलना चाह रहे थे कि अगर किसी को हिंदी में कोई प्रश्न पूछना है तो आप प्लीज पूछिए, क्योंकि उसका रिस्पांस ऋत्विक हिंदी में ही. Sahil, are you there?
Yeah. Hey, Nima. Hi.
Hi.
Yeah. Sorry, I'm not in a position to talk very much right now. But could you read out the questions that I sent you? I'd really appreciate that.
Okay. Thank you.
Thank you.
So, Ritwik, Sahil's question was, what would be the implications for the unclassed state forest of Arunachal, which currently form the bulk of the forest in Arunachal? The FD's role in them is undefined and varies from place to place, and from no role at all or a figurative admin role. So there are no de jure rights rights of people in Arunachal unclassed state forest, unlike other community forests in some of the other northeastern states like Mizoram, Meghalaya? How will the FCA amendments and exemption for border roads within the radius of 100 kilometers affect these forests in terms of opening up for development? Also, there have never been cadastral surveys in these forests in terms of clear demarcation of ownership and governance. Would that affect forest status now, more especially with the FCA amendments? Ritwick?
Can I answer this? So my response to that is that firstly, unclassed state forest is forest. Right? Because what it uses the word saying that if it is forest in any government record, the moment it is used, the word state forest, the provisions of the Forest Conservation Act will apply. Right. So my answer to your question is yes, is that FCA will apply to all categories of forest, including unclassed state forest, so far as Arunachal is concerned. Now, the issue that comes up is with regard to linear projects of strategic and national importance. In those instances, they will not require to go to the central government for prior approval. The agency to approve those diversion will be the state government itself for diverting the forest land. So therefore, they will still have to follow the process of the Forest Act, which is applicable in the state. That will have to be done, but prior approval of central government will not be required, but approval of the state government will still be required.
Yeah, thanks, Ritwik. I think there is another question from Manipur, which is pretty much similar because there are concerns about what happens to the rights of the ethnic communities who live in these forests. So the question is what happens to the forest on Manipur hill tracts covered under Article 371C of the Constitution? Its possible impacts on forest land ownership vis-a-vis rights of the ethnic tribes. Would there be any impact on the rights of the ethnic tribes?
Can you just repeat the last part? The first part of it, it said Manipur hill tracts.
Covered under Article 371C of the Constitution.
Yes.
Its possible impacts on forest land ownership vis-a-vis the rights of the ethnic tribes.
The Forest Conservation Act does not impact the ownership at all. Right? It is one thing that is there is Forest Conservation Act only relates to non-forest use. So therefore, so far as practices like even Jhum is concerned, the FCA does not come into the picture because even a Jhum cultivation is a forestry use. So therefore, and second is ownership of forest land can go to anyone, whether it's under 371, under 6th schedule. FCA is not concerned about ownership. FCA is only concerned about breaking up or clearing of land for any use which is non-forest in nature. That's the only part that is there, subject to definitely special constitutional provisions which are applicable where the local customary practices are protected. So therefore, under this provision, there's no impact so far as rights or ownership is concerned. Even in the Aravali case, Devesh Bhutani case, the Supreme Court very clearly stated that the whole of Aravali area, the Forest Conservation Act will not come in the way of ownership over private forest land. It will only come in if you build or do activity which is not permissible in a forest area.
Thank you, Ritwik. I think there was a question from Priya Sethi about Nagaland. Priya, do you want to ask your question?
Yeah, thanks, Nima. Ritwik, it's similar to the Arunachal and Manipur questions. I'm interested in Nagaland, where, as you know, Article 371A applies. And under that, for the Forest Conservation Act, it only applies to government lands currently, because the Assembly only said it applies to the government-owned forest lands and not to the unclassed and privately owned forests. But it was widely believed that the Godavarman judgment extended this applicability to all the unclassed forests. And currently, I think the Assembly is considering actually passing a resolution not to adopt the FCAA. So currently, where does it stand in terms of the applicability of the FCAA? I know it doesn't apply to ownership of lands, but whether it's in terms of breaking up the land for any other purposes because of the 100-kilometer exclusion zone. So what would the interpretation be, you think, for these areas?
See, my interpretation there, subject to a lot of people can have very different interpretation. So please don't consider that this is the last word on the subject. It is my own personal view based on my reading of the law.
Right.
That the FCA does not, including the amendment, does not interfere directly with the power of the state government.
Right.
In order to decide whether it wants to divert forest land or protect forest land or maintain status quo. The state government's power remains intact. Right? What it does is basically takes away the power of the central government to take a call. Now, if there is a project that the state government wants, as per the provisions of the Forest Conservation Act, the state is the authority to decide on it. Right? Even in areas which are under 6th schedule or 371A or even outside.
Okay.
The FCA has been problematic because many of the states felt like the power has been usurped by the center, though they do not own the land. And suddenly they will have to go with proposals before the central government. Whereas now the entire power is with the state. It has also been a very interesting political tool, or at least public tool, where we have seen local politicians saying central government ne forest land divert kar diya, hum to bachane chahte the. Right? Now that is a wrong idea. Agar state bachane chahta tha to bacha sakta tha. Right? Lot of chief minister go and say, "Arey hum to aapke saath hai, par central government ne ye divert karwa diya." Arey divert karwa diya to aapne proposal aage bheja kyun? Right? So therefore, FCA does not at all, even with the amendment, interfere with that power or the relation that exists with the local community over the land, or the ownership that exists with it, and also the power of the state government vis-a-vis its decision-making capacity.
Okay. Great, thank you.
Unless Neeraj, if you have any point to add to it, I may have left out.
No, I think you perfectly clarified. So, though I have not studied this law amendment in detail, it has stumped me why some state governments are opposing it, because actually they are getting more powers in one way. But anyway, that's only my personal view. And I would just like to, not relate it to Northeast, but I remember a NGT order many years ago that a mining company, Hindalco, had approached NGT that please ask Maharashtra government to submit the proposal for mining. So NGT said, we can't tell a state government to submit a proposal for mining. So both submitting the proposal and eventually diverting the forest land is the state's prerogative, which the courts can't interfere with. So just what Ritwick already clarified, but I just thought I'll add my 2 bits in that.
Thanks, Neeraj. Thanks, Ritwick. The next question is from Shripad. Shripad, would you like to ask your...
Hi, Nima. Before we move on to Shripad, I think Aparajita Dutta has a comment which is similar to the conversation we're having. Maybe she can take it up.
Yeah.
I have a question to Ritwick.
Prafullaji, could you mute yourself for some time? We can take your question up later. Aparajita, could you maybe unmute yourself and...
Okay, yeah. Hi, Ritwick. Thanks for clarifying many things, though I'm actually a bit more confused because I think it's so confusing and I don't know how states interpret all this and how they'll have the formats or templates now to follow this process, and every state might do different things. But my question, actually, I put it in the comment because I thought that will be read out. is that my understanding is Arunachal is not a Schedule 6 state, unlike some of the other Northeast states, and does not have the special, protection and rights that in relation to governing their land. I don't know if I'm wrong about this, but under this article.
Parishita, I got disconnected for about 10 seconds.
Oh, okay.
Sorry.
So yeah, Arunachal, I'll just read out the question I'd written in the chat. Is Arunachal is not a Schedule 6 state, unlike some other Northeast states, and does not have the special protection and rights that are applicable to some other Northeast states. I may be wrong in my understanding of this, but under Article 371H, in the case of Arunachal, I think the governor has supreme power to decide. So how, and given that Arunachal is usually in line with central government, and given that, in the JPC report, you may have seen that many of the Northeastern states oppose the, this 100-kilometer exemption, whereas Arunachal actually said 150 kilometers. Why is it not 150 kilometers? It should be 150 kilometers. So, here is a case where the state government is actively in line with what the central government also wants, and which may not be in line with what local people want. So that, in that sense, Nima's question also becomes important, because if now the states have to put some rules, about, I don't know how that will operate. So yeah, it's a very large question. I don't know.
See, the thing is that I think what they don't want to do, I'll be very honest, is, again, let me state very clearly that many states, and also let me be very blunt, forest officials don't want to fill up this whole FC forms, right? Because it's a bundle of lies that each officer knows they're filling up, right? If you go by the forms that the forest officers submit across the country, it will be clear that India has not a single wild animal. There are no trees. There is not a single area of biodiversity value in the country. Right now, to process that proposal further, they have to write nil in every single point. We have seen in Arunachal, where with respect to Demwe project to all, not a single mention of any animal. And then you find there are tiger, there are hulak gibbon, there are everything in that site. And you have 2,000 square, 2,000 hectare forest land been diverted with not a single species of animal listed. So therefore, let me be very clear that there is one category of people who are very happy not to have the Forest Conservation Act, unfortunately, are the forest officers. Many of them. There are very good officers, let me be very respectful, but there are many who don't want to do this. So therefore, they're using this as an opportunity to say, well, let's not require forest clearance for all of these projects. That's why this whole idea of 100 to 150 comes in. Because they know that tomorrow, even in those rare cases which go to court, they'll be howled up for giving such false information and blatant lies. And therefore, there's a whole aim that let these projects not be evaluated, let it be automatically approved, let it be the least amount of scrutiny that takes place.
Yeah, thanks. Yeah, concerning.
So maybe Prafulla ji can ask the question.
Ritwik, when the government of India will approve any project and directly say that there can be privatization of or forest land within reserve forest or notified area without the consent of the state government. So there is no mention of also that it will be followed by Gram Sabha other thing. Suppose the state government also makes okay. So what will about the fate of the local people? Are they compelled to go only the court of law to implement the Forest Right Act? So there will be not only the conflict between the FCA and also the Forest Right Act, and that will be solved on the court. I think this this should be clear. What should we do? How the state government has power also. When many state governments wants to divert, so that is they welcoming. They are welcoming to the also the central legislation. It's like Odisha state government has not opposed it. So I think what will when conflict will be there always. Secondly, in you know that you are the first, you are the advocate who has led us to win the Niyamgiri judgment in Supreme Court. But there we have now, after that is delinking the forest, that is the deemed forest, everything. Now Niyamgiri is also patches of deemed forest. So far record is 1927 record is concerned. So now the companies are maybe the Vedanta company also can dare to apply those lands for mining within Niyamgiri. Is it possible? What to do it also? That is my question.
Thank you, Profulji. Pehle to good to see you. I know you had gone through difficult last 1 week. So happy to see you online. तो अच्छा लगा आपको कि आप safe हैं and जो भी हुआ है.
I am safe. I was kidnapped, not the company goons, but for company, the state police department has kidnapped me as a criminal. So because the pressure, public pressure like you, all the government has to rescue me. Any thank to all.
Thank you. देखिए प्रफुल्ल जी जो what my answer to your question is that देखिए हमारा ये कहना है कि देखिए deemed forest is still a forest under Forest Rights Act. Let's be very clear. Deemed forest is a legal category. It is a statutory category. And the amendment to the Forest Conservation Act cannot take away the category of deemed forest. Right? And therefore, this law, and because I'm again repeating that if there was a clause in this Forest Conservation Act saying notwithstanding anything contained in any other law, it does not override the provisions of the Forest Rights Act. And since it does not override the provisions of the Forest Rights Act, therefore, they cannot interfere with the right of either the Gram Sabha and others so far as diversion and others are concerned. But I'll add, we need to work because all the proposal for diversion and all are based on, the idea that it will go to central government. But deemed forest is forest land, and deemed forest is also entered in government record. देखिए इसमें very important point है, ग्राम जंगल जोग्य, ग्राम जंगल are all government in some record, even a panchayat record. Okay. So therefore, it is to be treated as forest for the purpose of forest conservation. और इनका जो interpretation है कि because it is not notified under IFA or declared as forest, reserve forest, it is not a forest, is not a correct interpretation even in terms of the Forest Conservation Amendment Bill or now Act of 2023. And एक और मैं बताता हूँ जो which is important, which is not of great value but still of some value, कि जो JPC के सामने जो submission that was made by the Ministry of Environment and Forest said that deemed forest will be treated as forest, right? Because the expert committee of the states, wherever they have considered these areas as forest, also are government record. So therefore, they will be treated as forest. So my interpretation is that they cannot consider deemed forest because in some record of the government, it is treated as forest.
Ritwik, there is a similar question since you're talking about deemed forests. So there is a comment from Sehjivan about grasslands and deemed forests. So Sehjivan, आप अपना, मुझे मालूम नहीं कौन है अभी सहजीवन से, तो आप अपना क्वेश्चन.
नीमा, मैं रमेश में लिख रहा था वो ये. एक्चुअली गुजरात में बहुत सारे ऐसे फॉरेस्ट एरियाज हैं जो कम्युनिटी के डीम्ड फॉरेस्ट है, जो जिसके ऊपर वो ग्रेजिंग के लिए डिपेंड करते हैं और माइनर फॉरेस्ट प्रोड्यूस के लिए भी. ठीक है. अब वो पूरी जमीन का जो एडमिनिस्ट्रेटिव कंट्रोल है वो रेवेन्यू डिपार्टमेंट के पास है. अब मानो कि कम्युनिटीज अपने एफआरए के क्लेम डालते हैं वहां पे अपने कम्युनिटी राइट्स, ग्रेजिंग और बाकी सब उपयोग के लिए, और उनका कंट्रोल भी है. तो इन दिस केस उस जमीन को रेवेन्यू डिपार्टमेंट इधर विंड मिल्स और कोई सोलर एनर्जी और माइनिंग, ये पर्पस के लिए आराम से अभी क्लियरेंस दे रहे हैं। तो कम्युनिटी के पास कंट्रोल नहीं है और रेवेन्यू डिपार्टमेंट ग्राम सभा के पास अप्रूवल के लिए या उनका प्रायर कंसेंट के लिए कोई प्रक्रिया नहीं करते हैं। इन दैट केस एफआरए का एप्लीकेशन होने के बावजूद, मतलब क्लेम डालने के बावजूद या उनके कंट्रोल होने के बावजूद ये कॉन्फ्लिक्ट है, तो इसको कैसे देखा जाए, इसका सॉल्यूशन क्या है?
देखिए, अगर आपके कोई भी सरकारी डॉक्यूमेंट या कम्युनिटी डॉक्यूमेंट या ग्राम पंचायत के डॉक्यूमेंट में वो जो इलाका है उसको अगर आपने फॉरेस्ट माना है, उसमें फॉरेस्ट वर्ड जंगल, जंगल जैसा जंगल किस्म का, बड़े झाड़, छोटे झाड़, कोई भी कैटेगरी का एक आपका जंगल के लिंक्ड एक वर्ड होना चाहिए। अगर आपकी कम्युनिटी के रिकॉर्ड में, देखिए यहाँ पर इस कानून में साफ लिखा गया है कि रिकॉर्ड्स मेंटेन्ड बाय द कम्युनिटी आल्सो इज टू बी ट्रीटेड एज फॉरेस्ट।
ओके,
राइट। तो आपका वहां पर ये नहीं, क्योंकि ग्राम पंचायत भी जो है उसका रिकॉर्ड भी कम्युनिटी है, लोकल बॉडी भी वर्ड यूज किया गया है। तो अगर कोई भी ऐसे डॉक्यूमेंट में वहां पर लिखा गया है कि ये जंगल है, जंगल के तरह है, जंगल लायक है, तो उसके ऊपर फॉरेस्ट कंजर्वेशन एक्ट लागू होता है। और उसमें अगर वो विंडमिल लगाए या सोलर के लगाए, वो सब जो है प्रोजेक्ट को फॉरेस्ट कंजर्वेशन एक्ट के अंतर्गत उनको प्रायर अप्रूवल चाहिए। और ये जो नया अमेंडमेंट आया उसमें कोई एग्जेम्पशन नहीं है इस तरह का, क्योंकि ये नाइदर स्ट्रेटेजिक है, नॉर लीनियर है, नॉर पब्लिक यूटिलिटी का है, क्योंकि ये लेफ्ट विंग एक्सट्रीमिस्ट एरिया में नहीं है।
ओके सर, प्रॉब्लम यही है कि क्योंकि इसका पूरा कंट्रोल रेवेन्यू डिपार्टमेंट मींस कलेक्टर और मामलतदार के पास होता है, तो वो ग्राम सभा से कोई अप्रूवल की प्रक्रिया ही नहीं करते हैं। गांव के लोगों को मालूम भी नहीं होता है कि ये जमीन किसी को ट्रांसफर कर दी गई ऑलरेडी। तो इसमें लोगों को क्या उनके पास पावर्स हैं ताकि वो डाइवर्जन को रोक पाए?
देखिए, इसके अंतर्गत हम बाद में बात कर सकते हैं, पर अदरवाइज अगर कोई लीज ऑफ प्राइवेट लैंड भी हुआ हो, राइट, लीज ऑफ प्राइवेट लैंड, फॉरेस्ट लैंड भी होता है, नॉट ओन्ड बाय द गवर्नमेंट, और उसको नॉन फॉरेस्ट यूज में है, तो वो फॉरेस्ट कंजर्वेशन एक्ट का उल्लंघन में है और उसको आप चैलेंज कर सकते हैं। बट इतना डिटेल में मैं अभी तो कर नहीं पाऊंगा, बट नीमा को मैं रिक्वेस्ट करूंगी कि हम लोग बाद में बात कर सकते हैं और मैं आपको सजेस्ट कर सकता हूँ क्या कर सकते हैं।
श्योर श्योर, थैंक यू।
Thank you, Ritwik. There are a set of questions again related to Gram Sabha consent only. Like Sharanya has also asked similar question as Prapulita was asking earlier on. So now under the FC, if there are violations, like for example in Bastar, if there are these security camps being set up, then one cannot ask for Gram Sabha under FRA, is what her question is. But what you had earlier said, that we would have to ask for a similar process and for the state government's proposal for diversion. But if you have to add anything more to it, please.
No, according to me, they will still require a Gram Sabha, for which the amendment or not amendment, changes of the rules will have to be, or a format needs to be developed. Because as of now, all these are based on the fact that it will go to the central government for the final approval and they will examine the documents. Whereas now, all this will have to be looked at by the state government, and it becomes the responsibility of the state government to ensure compliance with FRA. As of today, the responsibility to look into FRA compliance, final authority is the central government. Ironically, the Ministry of Environment and Forest, and not the Ministry of Tribal Affairs. It is the Ministry of Environment's Forest Advisory Committee or the Regional Empowered Committee, which has to look into whether the FRA process has been completed or not. Right? Today, what we need is post FC Act amendment. That process will have to go to the state, saying that if it is security related infrastructure up to 10 hectares, then also they would need the Gram Sabha, because Section 5 of the Forest Rights Act is very much applicable. It is not undermined by this law, and therefore they will have to come out with a format for this. Now, in coming out of the format, the problem that will essentially come in is essentially either Ministry of Tribal Affairs comes out with a format or every respective state government comes out with its own format. For projects where final decision maker of forest land is the state government.
Thank you, Ritwik. There was another interesting question by Sharanya, which says that even though there is an exemption for surveys, for example, in Koraput, she's given an example that survey is happening in a small area, but what about the road infrastructure that comes for surveys? Would those be also exempt?
No. See, the word that is there, because there were cases that were already gone, it is the exact site and the survey and reconnaissance. Usually, if it is a road and others, then here also, they've said that the central government will come out with guidelines as to what is survey and reconnaissance. So therefore, there will be guidelines framed. So we will have to wait for the guidelines, because they've just broadly said can be exempted on case subject to guidelines to be framed by the central government. So one will have to wait for the guidelines as to what they mean by survey and what it would mean, that because in certain instances it's very clearly said no felling of trees will be involved. No, you will only do, those particular structure at a very limited scale. So therefore one has to maybe wait for the guidelines to come out.
Okay, thanks. And then there are a series of questions. Again, Soma has a question saying in Uttarakhand, there are roads being built, the Nepal highway in particular, where there is, people have been opposing it, but it is almost given as fait accompli, because they just have to accept the compensation and accept that there is a road coming. There is no other way of opposing except going to the court.
See, the Gram Sabha consent, if you are aware, you are definitely aware, was already taken away, taken out of the purview of Forest Rights Act and FC Act many years back. And that is the problematic part. So no Gram Sabha approval is required in any case for road construction or linear project. And secondly, they've also largely exempted all road projects from the purview of EIA, because if it is less than 100 kilometers. So therefore, the environmental regime for roads and highways, especially in border areas, is anyway almost non-existent as of now.
Thank you. Manshi, you had very similar question for Himachal. Would you like to ask your question?
Hi, Nima, Ritwik. So yeah, this of course the pressure from the center, the dependence on the center for finances and other kind of dependence, that makes it difficult. I think Aparajita already asked that. The other aspect is that the forest department does not have a structure like an FSC, the expertise to kind of look into and examine proposals. So, it'll have to set up a whole structure. Does this happen on its own, or it'll have to be demanded for? That is something that I wanted to ask. And also, now, in terms of the Himalayan region, there are two types of projects. I just wanted to clarify this. Do we read strategic and linear as separate, or do we read it together? And for instance, you have hydropower projects which are not linear, but the transmission lines are linear. And the hydro projects are already being built. So then won't transmission lines anyway become fait accompli? And how will the state forest department say no to that, or the community say no to that? That remains a question even now. And that is, and the other is for roads also, for highways and roads. These two are going to be essentially what the government will push. And they are both central government. Strategic linear projects itself are the center's, interest in a way. So where does the state government stand then?
So first and foremost, Manshi raised again very important. In fact, I was going through that provision, yesterday only. So if you look at the amended law, it says such forest land as is situated within a distance of 100 kilometers along international boundary, LOC and line of actual control, as the case may be, proposed to be used for construction. Now, it's a very important point. Proposed to be used for construction of strategic linear project of national importance and concerning national security. Now, if you look at here, they do not use the word or concerning national security. So a hydropower project, right, is very difficult to be clubbed. I'm not saying impossible, difficult to be clubbed as a national security, because it says a strategic linear project which is of national importance. So a hydro may come with the power line is of national importance. But again, along with it, the parliament has used the word and concerning national security. So therefore, it will have to be a security related activity. So if it is a hydropower project which is providing power to Punjab and it's there in Himachal, and it's a purely commercial one, it is not a security related. So therefore, that project will not come under the exemption clause. And if they'd used the word or, then it could have. But they've used the word and. And moment and has been used, then it is national importance and national security. Both have to be satisfied, and it has to be a linear, and it has to be a strategic linear project. Now, with regard to your first one, yes, the forest department does not have the system in place, largely because of the fact that it is used to getting, say, the survey done by a range officer, then or an ACF, then given to the DCF. DCF forwards it to either CF or CCF. CCF then sends it to the PCCF. PCCF sends it to the secretary. Then secretary sends it to the FSC or REC, as the case may be. Within the forest department or the state government, there is no particular body which is existing, which is the capacity to evaluate a project holistically. That is something that would be needed. So because you see, when you look at FSC, Forest Conservation Act, it talks about the FSC as a national level body. Then you have a REC, which is a regional level body. But once you've given the power to divert now to the state, there would be a requirement for a similar body at a state level.
Thanks, Ritwick. I was actually just trying to club questions together so we don't keep coming back to the same issues. But Rajshekhar ji, you want to ask your question? Rajshekhar?
Yeah, thank you.
Sir, Ritwick sir, just I interacted with you just like a few years back related to elephant corridors protection due to the coal block era while I was associated with Vimta Labs. And my questions are two-pronged. One is the elephant corridors are not taken care of in the wider segment because they're the corridor area is not being digitized by the forest department. At times, the state is recognizing, when center is recognizing the elephant corridors, state departments are not giving the due importance to the elephant corridors, especially in coal block states. And it happened in few northeast states like in Arunachal Pradesh. I'm referring to issue in Holangi and also the issues I faced in elephant corridors related to Incorporated region. Hello?
Yes. Your question is with regard to elephant corridors.
Elephant corridors. And also another question is, after elephant corridors, I would like to ask regarding the destruction of pristine forests for Car Nicobar region. So why the center is interested to take up the plantation in semi-arid region of Haryana? How ecologically it is valid?
To one of your questions don't directly relate to the this
Yes,
amendment, but my only response is that, see, the problem that comes out with this law is that it gives it gives almost absolute power in many sense, right, to the state as well as the project proponent, to demand forest land irrespective of its sensitivity. So
Yes.
say today you say that, well, I need this area for security related infrastructure. It doesn't really matter whether it's part of an elephant corridor or not. And,
Yes.
and that is how a lot of efforts, and that's what I've been saying, that I didn't see that the impact of this amendment on wildlife and migrations and corridors will be severe, because every entity can take 5 hectares, 4 hectares, 2 hectares, 3 hectares next to each other. Now, what will be the impact on wildlife is also secondary. How it will aggravate the human-animal conflict is an issue of serious concern. Animals have been moving. Now, one agency of the defense force come and says, well, I want this for a football field. What happens? I want it for a golf. Let's be very clear. Just because it made infrastructure and security doesn't necessarily mean it'll be trenches and rocket launchers there. It can be very innocuous one. It can be a shopping. It can be a marketplace. It can be anything which is required by them. And in that process, the problem is we are completely depending on the state, right, as to being the decision maker. And usually the pressures are such that the states have normally not been able to withstand the pressure that comes from different agencies, especially when it comes to security and others. So when it goes to central government, at least there is some hope that even if it is not stopped, at least some effective mitigation can come in. That's how, if you look at it, some of the most significant orders, even from the government of India and others that have come in, right, with regard to elephant corridors and tiger corridors and all, has come in through the FC process, the Forest Conservation Act process, and not through the wildlife clearance process. So when you're using diverting forest land, they would say, well, have an overpass, have an underpass, divert it from that area, move it to another place. Those things are possible. Now that possibility is gone, because most of the decision will be at a local bureaucratic level where where such holistic level of understanding may not be possible.
No, sir. Yes, I will add one point. It happened in Udhampur Nagar, when the elephant calf and baby calf were all hit by the moving train at a breakneck speed. So the plant is close to the elephant corridor area. The DFO in Haldwani gave a letter in a cheeky manner. Sorry for saying in a manner. Elephants might be there, leopards might be there, and tigers might be there, despite knowing it is in transit between Indo-Nepal corridor area. As if they can come from a magician's hat, they gave a letter. And the letter was very helpful for the agency. I'm not mincing the words. The agency is Vedanta. And it was forcing me to write an report for their favor in Sterlite. So I put papers and moved out from the consultancy agency, the Vinta Lab. The same report, the endangered animals which I wrote, most of them, my report has been expunged. So, and Niti Aayog is helping them.
Thanks. Shripad, you had a question. Shripad, are you still there?
Nima, he's left. I think we can move on to the next.
Oh, he's left. I think his question was that you mentioned that the areas which are going to be restored then will be out of the purview of the Forest Conservation Act. So he was asking, can't they be declared reserve forest? I think that was one of his question among others.
See, there's no bar of those areas being declared as a reserve forest, but for the purpose of Forest Conservation Act, It doesn't necessarily need to be a reserve forest. It just needs to be recognized as a forest, right, in any record. So why have it as a reserve forest when there are so much restriction even with a reserve forest? Even if it is in any category recognized as a forest in any records of the government, that is good enough. Now, in case of, say, the whole Aravali case was successful only because we were able to prove that a closed area, right, is a forest within the meaning of for purpose of forest conservation, right? So it doesn't necessarily need to be specifically declared as a national park, sanctuary, reserve forest, or even a protected forest to be recognized. That's what I'm saying. Even a common term like jungle jaisa, jungle kisam, jungle bade jhad, chote jhad, that is good enough to bring it within the purview of the Forest Conservation Act. And again, which I keep repeating and again repeat, is Forest Conservation Act. Now, because see, the greatest fault with this whole law, let's look at it here, is the packaging is so faulty, or it's, let's not say faulty, it's so much of falsehood. They're saying, well, the Forest Conservation Act has come in the way of people planting more trees. Well, the Forest Conservation Act does not apply to trees, right? It only applies to non-forest use of forest land. You can plant as many trees as you like. You can cut as many trees as you like. Plant and cutting is not regulated under Forest Conservation Act. It's like the Biological Diversity Act. You look at it here. I'm just diverting. What have they stated? In the statement of objects and reasons, they have stated that the most effective way of encouraging people and farmers to grow medicinal plant is to do away with access and benefit sharing. Now, what is access and benefit sharing? The company has to pay, is required to pay at least a part of its revenue to the farmers who are growing medicinal plant. Now, the government said, now companies will no longer have to pay farmers money to grow medicinal plant. Therefore, more farmers will start planting medicinal plants. Now, that is absurd. Agar aap unko kam paisa doge to lagayega kyun? There was a benefit they were getting. Now, here also they are saying what is coming in the way is the Forest Conservation Act in terms of tree planting. Forest Conservation Act does not apply to trees. It does not apply to logs. It does not apply to timber. Those are regulated by the Tree Preservation Act of the respective states. So this is again a misconception that has been created here, that the only way in which India can increase its forest cover is to divert more and more forest land. It's absurd. It defies logic. And that's how the entire packaging has been done.
Thanks, Ritwik. Just to clarify, so when you say that they just have to be recorded as forest, so it could be a Gram Sabha in their records recording these their restored forest as forest. It could be a Panchayat restoring it, recording it as forest through a resolution, right? It could be a simple survey done by a Gram Sabha and recording in their records, or a village council, or whatever the body.
Yes, see, I'll go by here. See, if you read the law itself, what it says is, for the purpose of this section, the expression government record means record held by Revenue Department or Forest Department or Union Territory Administration or any authority or local body or community or council recognized by the state government or Union Territory Administration. So according to me, if a PBR records it as forest, it is forest. As simple as this. If today every single PBR records all these areas as forest, in the record that is recognized by the government, the provisions of the Forest Conservation Act will apply. And they've used the word local body. So Panchayat is a local body. So therefore, the word is any local body is using the word forest. It is forest for the purpose of forest conservation.
Thank you. Suhastai, you want to ask your question? Suhastai?
Yes. Before the question that I had put in the chat, just connecting with Ritwik's statement just now, but your this FCA states that it has to be recorded prior to 25th October 1980. And most of the Gram Sabha records and all have been updated after the Forest Rights Act has come. So is that not going to create problem? That is my one question. The other question which I had put in the chat was, most of these acts coming up these days are to help the corporates for ease of doing business. And that is what we are afraid of, that by diverting the lands, they want to give it for mining and palm oil cultivation, as it is probably a hidden intention behind the whole Manipur burning. So how do you look at this? Thank you.
Thank you. See, the thing is here, if you look at the section, it says land that is not covered under but recorded as in government record as forest as on or after 25th October 1980. Right. So it does not refer to only situation before 80. It says it is as on 80 it was forest, and even after 25th October 1980 it is recorded as forest. So therefore, because again if we look at it, it could not have been the intention of the Forest Conservation Act to state that you cannot further record areas as forest. It is impossible. That there is, if that is so, that would mean that there is this law would mean that no new area will be recorded as forest in any record anymore. That is not. So here it can, if it is on record, it is forest. And if it is put on record even now, it is a forest, because recording of forest is an ongoing process. So therefore, every panchayat record in the past, in the future, in the present, if they include it, it is to be treated as forest.
But Ritwik, then how did you go receive the decision of Godavarman is already it's affected? If that is so, then how the Godavarman decision has been now is affected by this amendment?
See, the thing is that
my question about ease of doing business has remained.
Sorry, last one I missed out.
I said that there is a feeling that most of the new laws and changes in the laws are in view of the ease of doing business and for giving licenses for mining and palm oil cultivation, as is said to be the basic reason for the whole Manipur burning. And in which case, if only state is the person to give the permissions, then it is probably easier to manipulate. So I wanted your opinion.
No, there is a problem. You see, there is a problem of the states, despite all of support for federalism and for more decentralization. There is a problem when the entire power is vested on one authority, whether it is center, whether it's state. There has to be a balance, and that balancing is what was done by the Forest Conservation Act in 80. That there will be both involved. State will put a proposal, center will say it, it may not reject it, it may say, well, modify it, come back. So there were more people involved. Now the problem that I see it is that you have completely given liberty to the state. That is why what Neeraj was also saying, that one is little surprised as to why states are opposing it. One doesn't find the reason for that. Because in a way, this law has done just the opposite, is to convert everything back to the state, like what they did with the wetland rules. They abolished the National Wetland Authority and created a state wetland board, and the state wetland board is to do everything, which is basically doing nothing till now. So in a way, the problem that I see it is contrary to what many states are now stating is, well, it is too much of delegation or surrendering of power to the state government without necessarily safeguards. And that is going to be problematic in respect of all of it. Because if you look at it here, they've said silviculture is also an activity that is there. Now, what is silviculture? right? They can say, well, plantation, tea, coffee, all this can be again manipulated or put in some form of silvicultural operations. So we'll have to actually look into these aspects, and there is no doubt that ease of doing business and all has been the basis for almost all the amendments in the law.
Thank you.
So, Ritik, how you should clarify now how this amendment has changed also the decision of Godavarman decision. That is my point. What is the effect on the when you say there is any community land or revenue or recorded or then the deemed forest has not been affected, then in what way the decision of Godavarman decision has been affected?
No, what I'm saying is decision of Godavarman has not been affected. Forest Conservation Act 1980 is affected. And how it is affected is that number one, and this is a very important point Prafulji jo aap bol rahe hain, ki abhi tak, what did Godavarman's judgment say? That each state will constitute a committee to be known as an expert committee to identify areas which are forest, which were forest, and which fall within the dictionary meaning of forest. Right? उसके बेसिस में states were to identify and do a task. अब देखिए फॉरेस्ट का जो डेफिनेशन है डिक्शनरी मीनिंग, सुप्रीम कोर्ट ने गोदावरी ने कहा कि फॉरेस्ट मस्ट बी अंडरस्टूड इन टर्म्स ऑफ डिक्शनरी मीनिंग. What is dictionary meaning? Supreme Court did not go into that. He said it is for every state to come up with dictionary meaning. So Himachal में 5 trees per hectare naturally grown is forest. राजस्थान में रॉकी आउटक्रॉप इज फॉरेस्ट. लद्दाख में आपका फॉरेस्ट का डेफिनेशन अलग होगा और केरला में डेफिनेशन अलग होगा. राइट ना उसके बेसिस में जो एरिया नोटिफाइड फॉरेस्ट है वो तो क्लियर है, आरएफ है, पीएफ है. जो नॉन नोटिफाइड फॉरेस्ट है उसमें ये एक्सपर्ट कमिटी अपने क्राइटेरिया बनाएंगे. उस क्राइटेरिया के अंतर्गत दे विल कम टू अ कंक्लूजन कि इस स्टेट के इस डिस्ट्रिक्ट में ये क्राइटेरिया होगा, दूसरे डिस्ट्रिक्ट में ये क्राइटेरिया होगा, और उन सब इलाकों के ऊपर जो है एरियाज के ऊपर फॉरेस्ट कंजर्वेशन एक्ट लागू होगा. राइट, ये एक प्रोसेस है. अभी व्हाट दिस हैज डन इज ये बोला है कि आपको जो है केवल नोटिफाइड डिक्लेयर्ड अंडर इंडियन फॉरेस्ट एक्ट तक ही सीमित होंगे. आप ये एक्सपर्ट कमेटी वमिटी में नहीं जाएंगे. राइट, बिकॉज ये एक्स्ट्रा काम था. एंड आज के दिन में प्रॉब्लम यहां आता है कि ऑलमोस्ट 50% स्टेट्स इंडिया का जो है दे हैव नॉट कंप्लीटेड द एक्सरसाइज ऑफ आइडेंटिफाइंग फॉरेस्ट. 50% जो लास्ट मीटिंग हुआ था ऑन आइडेंटिफिकेशन ऑफ फॉरेस्ट हेडेड बाय द डायरेक्टर जनरल ऑफ फॉरेस्ट वाज इन 2015. हरियाणा ने अभी तक अपना सर्वे और क्राइटेरिया फाइनलाइज नहीं किया है. उत्तराखंड ने नहीं किया है. डिस्पाइट हैविंग IGNFA, FRI, all forest academies there, they have yet to come out with a criteria. So वो प्रोसेस जो है जो चालू हो रहा था और अभी तक कंप्लीट नहीं हुआ है, उसके पहले उन्होंने बोला कि हम केवल इसको नोटिफाइड डिक्लेयर्ड एरियाज पे ही सीमित रखेंगे. हम इकोलॉजिकल कॉन्सेप्ट, डिक्शनरी मीनिंग क्या है, इकोलॉजिकल एरियाज को फॉरेस्ट को हम मानते ही नहीं. और अगर कोई इलाका में अपने मेहनत से एरिया में फॉरेस्ट रीग्रो किया है उसको भी हम इग्नोर करेंगे इफ इट इज नॉट नोटिफाइड इन अ गवर्नमेंट रिकॉर्ड. दैट इज वेयर द प्रॉब्लम इज. अभी तक लार्ज पार्ट ऑफ इंडिया में दिस प्रोसेस ऑफ आइडेंटिफिकेशन ऑफ फॉरेस्ट इज स्टिल नॉट कंप्लीट. सो व्हाई डिड यू सडनली कम आउट विद अ नोटिफाइड फॉरेस्ट व्हेन दैट प्रोसेस इज नॉट कंप्लीट? हमारे ये कहना है आप कंप्लीट करो प्रोसेस. Or if you complete the process, we will come to know how many area actually satisfies the meaning of forest, because word is Forest Conservation Act. The word is not Notified Forest Conservation Act. The word is not Government Forest Conservation Act. The word is forest, and that process is yet to be completed. And that is why Godavarman judgment has been violated, because they are not waiting. देखिए 96 में बताया गया था आप कमेटी बनाइए, कमिटी से आइडेंटिफाई करिए और नोटिफाई करिए फॉर प्रोटेक्शन. 2011 में लाफा जजमेंट में दे रिपीटेड इट, कंप्लीट द एक्सरसाइज अंडरटेकन इन 96 एंड वी आर इन 2023. दैट एक्सरसाइज इज स्टिल नॉट कंप्लीट. we still do not know how many area of India is within the dictionary meaning of forest or the ecological category of forest. And they have decided to dismantle the law by allowing states the complete power to divert these kind of projects, these kind of activities to do what they want.
Thanks, Ritwik. We are running out of time, but there are two questions, I think, from Nagaland. Maybe they can both be asked together and then you can respond to them. Ruchi and followed by Mr. Nuklu. Ruchi, you want to go first?
Yeah, so I just have a short question. For states like Mizoram that has already rejected the FCA, the amendment, and Nagaland is also thinking to reject the FCA amendment in the state legislative assembly. What will be the process of divergence and approval for those states that chooses to reject the new FCA amendment in their respective legislative assembly?
So as I said, for the states which are there, where the diversion proposals are, where the final decision is with the state government, the states will have to come out with a format for the same.
No, what I mean to say is, these allow state government to approve to the central government, but only rejected or stopped the
Hi, Ruchi, we are not able to hear you clearly. Your voice is breaking. Could you repeat your question? You're still inaudible. Could you maybe type your question? Until then, yeah.
Mr. Nuklu, you want to ask your question in the meanwhile?
Sorry, I haven't been able.
No, I think it's already typed. So if you can just, we have sent a question, so it's there already in the chat box.
Okay, so the question is from Lemsachin Lok. The FCA Act 2023, 3 specific locations, borders, line of control, actual line of control. We are given to understand that central government will have the final say to do anything for security reasons within these locations. If FCA applies only to government-owned forest and wildlife sanctuaries, Nagaland has more than 100 community biodiversity conservation areas or CCAs, which is completely managed by indigenous people, which doesn't come under state government's purview. So in the context of FCA 2023, what will happen to this indigenous community-owned conserved forests?
See, my point is that the central government will not have powers under this. The powers will still remain with the state. So therefore, it is not an instance where the central government can come in and say, well, you have to divert it for this purpose. So wherever the state, the land is owned or controlled by either the state or the community, that power is not taken away as a result of this amendment. As I'll repeat again, the same process is that the process will have to emanate from the agency that wants to use it. So for example, if the defense force wants to use it, well, they will still have to write to the forest department. The forest department will have to process it and then send it to the state government. So the process will still be, if it is a community conserved area, and as per the previous system also, if it needs consent of the community under FRA and others, that process will still have to be followed. Only thing that I'm saying is it will need some changes in the rules and regulations to ensure that these concerns are put in the format of the forms that are to be filled up while processing the proposals. But it will not be an instance where the central government can direct, that these areas should be diverted.
I think Ruchi's question is also related. So where the states have rejected the new amended act, like Mizoram has done and Nagaland is planning to do, what happens when there are roads of strategic importance? They will still have to
see, it won't mean much. See, rejection of it technically will mean that technically the central government's approval is not required, but the central government anyway says that it doesn't need to come to us. I hope I'm clear. See, what it says is that FCX Act says that before you do these activities, you need central government approval. Now the amendment says that you don't need the central government approval, and the state says that we reject this. Now, will it then mean that the states will have to continue to send proposals to the central government? Central government will say, well, we have no power now under this to examine your proposal. So you decide what you want to do.
Yeah.
But the government in any importance on any strategic on security, the proposal will come from the state, central government to the states.
Proposal will come
Then
from
state
the
may
agency
reject
that is
or
there. Yes, the proposal will come from the center, but the ultimate signature will have to be the state.
So last question from Pia, and then we wrap up for the day. I know that many questions have not been addressed, but we have to close. Pia, you want to quickly ask your
sorry,
question?
Ritwik, for belaboring a point, but any projects of national importance will come from the national level, the central government, right? And I agree, then it's up to the state to reject it or not. But what powers would they really have to exercise those kind of restraints in terms of rejecting any national proposal, which is of strategic importance? So I think that's the major question for states like Nagaland. I mean, they are all planning to reject the FCAA, but to what extent will it really help them to actually stop any kind of national projects?
See, that again depends on, say, I can give an example. Say, for example, the Neutrino Observatory, right, which received approval in Tamil Nadu, is rejected by the state government, though it's a project of national importance and security.
Right.
National importance. And they said, well, it's very important. Western Ghats is going to be involved. So as a state government, we do not want to give approval to the project. It's a central government project. Well, they got EC, but the state has said, well, we'll not give you consent to operate and will not give you forest clearance. Right. And the matter now in the Supreme Court, the state and the center are fighting, though the petition was originally filed by an activist only.
Right.
So it is not that it is impossible to happen, but it depends on the nature and how much the state is willing to actually defend its forest. Let me be very clear that the FC Act was used many a times by the state politician to say, well, it's the center that is diverting all the forest, whereas it was actually the state government which was doing all of it. Now it's time to hold the state government accountable for the forest itself.
Okay, great. Thanks.
Thank you. Thank you so much, Ritwik. You must be tired now after 2 hours of non-stop talking. Thank you so much. I think it's a very important note that you end at, that a lot of work needs to be done with the state governments now. And that would be another very important conversation that if we can at some point take forward, it will be useful to do even if in smaller groups with whoever is important. So very, very many insightful points from you, a lot of clarity. Thank you so much for accepting this invitation and for clarifying these questions. Thank you, Ritwik.
Thank you. Thank you, Neema. Just to tell you, it was extremely fruitful for me because, there are a lot of questions that I want to address, because I may not have the right answer to them, but it gave me an insight to it. And hopefully, soon we should be in touch to actually address these concerns, how best to take it forward, because for me, it was a great learning experience. Thank you.
Thank you. And thank you, Neeraj. Thank you, Akshay, also for handling all the background work. Thank you, all of you, for being here today. We should be in touch in future. Thanks, Ritwik, again. Bye-bye.